Abortion has existed in America since European colonization. In the early 1800s, methods were published for accomplishing abortion early in pregnancy. By the common law, abortion after 15 to 20 weeks after conception was not allowed, but without written statutes, the rules were hazy. When the United States became independent, most states continued to apply English common law to abortion. Connecticut was the first state to allow the medical abortion after quickening in 1821, followed by 10 of the 26 states creating similar restriction within 20 years. New York made post-quickening abortion a felony and pre-quickening abortion a misdemeanor in 1829. Before 1973, 30 states prohibited abortion without exception. Among those 30 states, 16 states banned it totally except in certain special circumstances which are rape, incest and held to mother. But on the day, January 22, 1973, everything changed in America. Because on that day, United States Supreme Court made abortion legal on every state. That law gave abortion as constitutional right, but not an absolute right to women. But again, the scenario changed when US Supreme Court struck down 1973 Roe vs. Wade verdict. In the new Dobbs vs. Jackson's Women's Health Organization verdict, Supreme Court gave every US state to design their own law regarding abortion. So in our today's discussion, we will going to discuss every state's individual stand on their own abortion law. Before getting to every individual state's abortion laws, first we have to understand abortion terminology, because it will help us to understand frequently used legal terms and provision used in reproductive rights laws. Legal terms, these are the things we have to understand from the abortion terminology. Fetal viability is the ability of a fetus to survive outside of the uterus. The Supreme Court and the American College of Obstetrics and Gynecology consider a fetus to be viable starting at between 24 to 28 weeks. Though there is no hard line, a fetus that cannot survive independently at any stage is considered non-viable. Even under Roe, most states restricted abortion after fetal viability, with some exceptions for fetal fatal anomalies. Almost all states' laws banning abortion make exceptions for the life-threatening pregnancies or medical emergencies. Also make exception in case of rape or incest. Weeks of pregnancy and the gestational age are both generally defined as the time since the first day of the last menstrual period before pregnancy. Some states ban abortions after a certain number of weeks post-fertilization, meaning the period after a sperm has fertilized an ovum and created a zygote. According to the US Center for the Disease Control and Prevention, 79% of abortion in US in 2019 occurred before 9 weeks and 93% before 13 weeks. Some states' law outlaws abortion at 6 to 7 weeks, before many women are aware they are pregnant. In addition, while abortion debate is often framed as a woman's right to choose, and many abortion laws refer to exceptions when the life of the mother is at risk, access to abortion does not only concern cisgender women. It also impacts anyone whose body is capable of getting pregnant, which includes trans men, intersex people, non-binary and the gender-expansive individuals. After understanding abortion terminology, now we need to understand trigger laws. What are the trigger laws and which states have them? The 1973 ruling in Roe vs. Wade established a constitutional right to an abortion during the first trimester or the first 3 months of pregnancy. It also determined abortion could be regulated but not be banned before fetal viability. Since then, state legislatures have passed many laws restricting abortion access, some of which has been struck down by the courts. Abortion-related trigger law delayed the effective dates until after a Supreme Court ruling jurisdictions over abortion to the states, with the court's decision in Dobbs vs. Jackson's Women's Health Organization doing just that. These laws will go into effect, though many states have already facing legal challenges. Arkansas, Idaho, Kentucky, Louisiana, Mississippi, Missouri, North Dakota, Ohio, Oklahoma, South Dakota, Tennessee, Texas, Utah, and the Wyoming all have trigger laws that ban abortion in the first trimester. With Dobbs overturning Roe vs. Wade, access to abortion now varies gently from state to state. Now we will going to discuss the all 50 states stand on abortion after Roe vs. Wade being overturned. Let's start with Alabama. Alabama passed a new abortion law in 2019. Alabama's HB 314 bans almost all abortion except in cases of life-threatening pregnancies. The law actually put on hold due to legal challenges, but will likely to go into effect with Roe vs. Wade being overturned. Until the law's current jurisdiction is overruled, abortions are prohibited after 22 weeks of gestation. The state also requires counseling, ultrasound, a 48-hour waiting period, and parental consent for minors. The next state is Alaska. The abortions are fully legal in Alaska, though state-directed counseling is required. In case of minors, parental consent is required. The Alaska Supreme Court ruled that abortion is protected by the state constitution. Alaska will decide in November 2022 referendum whether to hold a constitutional convention as a path toward banning abortion in the state or not. The next state is Arizona. A new law signed by Republican Governor Doug Ducey in March bans abortions after 15 weeks of pregnancy, except if necessary to save the mother's life. The physicians performing abortion face felony charges if they do anything against the state abortion law, and they will going to lose their professional license permanently. The statute is stated to take effect 90 days after the legislation adjourns its 2021-2022 session, which is likely to happen at the end of the June. Previously, Arizona allowed abortions until fetal viability, approximately 24 to 28 weeks. Arizona requires state-directed counseling, ultrasound, a 24-hour waiting period, and parental consent for minors. Now, Arkansas. A 2019 law, HB 318, makes providing an abortion a felony, punishable by up to 10 years in prison or fine up to $100,000. There is an exception in case of life-threatening pregnancies. Our next state is California, where abortion is legal until the point of fetal viability. In 2002, the California legislature passed a law that prevents the state from denying or interfering with an woman's right to obtain an abortion up to that point, or when an abortion is necessary to protect the life or the health of the woman. The Democratic Governor Gavin Newsom has pleaded to make California an abortion sanctuary state, establishing it as an haven for the people who need access to abortion, whether they live in California or not. He is also proposed amending the state constitution to further protect the abortion access. The next state is West Central State, Colorado. The Colorado allows abortion until fetal viability, though parents of the minors must be notified. In 2020, the voters rejected a ban on abortions after 22 weeks. In April 2022, Colorado lawmaker passed HB 22-1279, codifying protection for reproductive care including abortion, and also ensures that the fertilized eggs, embryos and the fetuses do not have the rights of personhood under the Colorado law. Connecticut also allows abortions only up to the point of fetal viability unless necessary to preserve the woman's life or health. The patients under 16 can obtain an abortion after receiving counseling from a nurse or a clinician. In May 2022, Democratic Governor Led Lamont signed first in the nation's reproductive rights legislation, making Connecticut an abortion sanctuary state. Starting July 1, the medical providers are shielded from the laws in the other states that have outlawed abortion, as are patients who travel to the state for abortion services and anyone who helps them. Next state is Delaware. Delaware law allows abortions until the point of fetal viability. In June 2022, lawmakers introduced House Bill 455, which would protect Delawareans who obtained, provide or assist others with getting legal abortions from facing civil suits in other states. It would also allow physician assistants and certified nurse practitioners and nurse midwives to perform abortions. The next state is Florida. In April 2022, Republican Governor Ron DeSantis signed a law banning abortions after 15 weeks. It's set to take effect from July 1. With exceptions to prevent serious harm or death of the mother, but not cases of incest, rape or human trafficking. The law is being challenged by the congregation Leader Van Dorn, which argues that the law violates Jewish teachings on reproductive rights. The next state is Georgia. With Roe now overturned, a 2019 Georgia law bans most abortions once the cardiac activity has been detected in an embryo, generally at about 6 to 7 weeks. There are exceptions for the cases of rape or incest, when a police case has been filed, and when a pregnancy has been deemed medically futile by a physician. The state requires counseling, parental consent for minors, an ultrasound, and 24-hour waiting period. Previously, abortion was legal in Georgia up to 20 weeks into pregnancy. Now, island state Hawaii. In 1970, Hawaii became the first state to fully legalize abortions up to the point of fetal viability. In 2006, the state amended its law to ensure full access to abortion services no matter what happened on the federal level. It also removed a requirement that individuals seeking an abortion be a resident for at least 90 days and allowed the procedure to be performed outside of the hospitals in clinics and doctors' offices. The next state is Idaho. In March 2022, Idaho passes a bill modeled on a Texas law banning all abortions after 6 weeks. The state Supreme Court issued a temporary injunctions, but with the Roe vs. Wade overturned, it goes into effect immediately. Previously, Idaho allowed abortions up to 22 weeks, with exceptions for life-threatening situations. In Illinois, abortions is legal until the point of fetal viability, and that isn't expected to change. In 2019, the state removed regulation for abortion providers with a law declaring fundamental right to abortion. Now Indiana, which technically allows abortions up to 22 weeks of pregnancy, but lawmakers have added strict limitations, including bans on abortion medications after 10 weeks and requirement for state-directed counseling and ultrasound at least 18 hours before an abortion. The regulations ensures that most abortions happen in the first 13 weeks of pregnancy. Now Iowa. Iowa allows abortions up to 20 weeks after fertilization and requires an ultrasound and permanent notification for minors. In 2019, the state passed a law banning all abortions after 6 weeks, but it was struck down by the Iowa Supreme Court. The status of that land won't change, even though the Roe vs. Wade is no longer the law of the land. Now Kansas. The Kansas ban abortions after 22 weeks and requires patients to undergo ultrasound and state-directed counseling. The Republican lawmakers banned dilations and the evacuation abortion in 2019, but the law was struck down by the state Supreme Court. In August 2022, the Kansas are slated to vote on an amendment denying state constitutional protection and the government funds for abortion. Now Kentucky. In 2019, the Kentucky became one of the first states to pass a trigger law that went into effect immediately after Roe vs. Wade was struck down. The providing surgical or the medical abortion is now Class D felony, except if necessary to save the life of the pregnant patients or to prevent the permanent impairment of a life-sustaining organ. The previously Kentucky allowed abortions up to 22 weeks. In case of minor, the parental consent is required, also ultrasound, state-directed counseling, and a mandatory 24-hour waiting period. In November 2022, the voters will decide on a referendum that notifying in a state constitution creates a right to the abortions or the requires government funding for abortion. Now the southern state Louisiana. In 2016, Louisiana passed a trigger law that bans all abortion except to prevent the sustainable risk of death or permanent impairment under certain circumstances. Basically, before Roe vs. Wade overturned, the state allowed abortions after 22 weeks of pregnancy and required ultrasound and waiting periods. In 2020, Louisiana amended its state constitution to remove any language that might imply right to an abortion. Now Maine. In Maine, abortion are allowed up to fetal viability and beyond that in case of life endangerment. In 2019, Maine codified legal abortion into law and passed legislation allowing people other than doctors to perform the procedure. In April 2022, the state passed a law designed to prevent the harassment of patients at abortion cases. In case of Maryland, abortion is legal until the point of fetal viability, though in case of minor, parents must be notified. In 1992, Maryland voters passed a referendum affirming access to abortion intended to protect abortion in Maryland in case the US Supreme Court overturned the Roe vs. Wade, and they succeeded in doing so. The next state is Massachusetts, also allows abortion until fetal viability. In 2018, the states passed a law removing outdated restriction on abortion. In late 2020, the state also passed legislation called Roe Act, which expanded access to abortion and made it explicitly legal in case of Roe vs. Wade being overturned, and they also succeeded in doing so. In Michigan, abortion are legal until the fetal viability. Through the state-directed counseling and the mandatory 24-hour waiting period are required. With Roe vs. Wade overturned, a Michigan law from 1931 could take effect, making all abortion illegal. But Governor Gretchen Whitmer has sued to block the law. saying that the due process and the equal protection clauses of the state constitution make it invalid. In case of Minnesota, its abortion restrictions are similar to Michigan's. However, Minnesota's right to abortion is protected by 1995 ruling by the state Supreme Court, and the governor Tim Walz has declared that no abortion ban will ever become law during his term. Mississippi has some of the strictest limitations on abortion in the US. Its Gestational Act 2018 was the subject of Dobbs versus Jackson's Women's Health Organization, the Supreme Court case that led to the overturning of Roe versus Wade. A trigger law passed in 2017 outlaws all abortion except in the cases of rape or to save the life of the mother. Missouri. Following the Supreme Court ruling in Dobbs, Missouri invoked a trigger law banning all abortion in the state except if the life of the pregnant woman is at stake. But no exception has been given in case of rape or incest. The new law also makes abortion a Class B felony with a possible prison of 5 to 15 years. Abortion providers can also have their medical license suspended or revoked. Now Montana. An abortion in Montana is protected by a 1999 state Supreme Court decision that isn't affected by the overturning of Roe versus Wade. However, State Attorney General Austin Knudsen had asked the Montana Supreme Court to overturn the 1999 decision. Several state abortion restrictions that were passed in 2021 are being challenged in the court by Planned Parenthood. The pending legislation could ban abortions after 20 weeks gestational age and block providing the abortion medication through the mail. Nebraska. An abortion in Nebraska are legal up to 22 weeks. In February, the state failed to pass a trigger law that would have banned all abortion when Roe versus Wade was overturned. Nebraska legislators have indicated that they may call a special session to try again to pass the bill. Nevada allows abortions up to until 24 weeks. In 1990, the state law revisions protecting abortion were passed by the referendum and cannot be changed by the legislature without a repeal from the state voters. New Hampshire has no specific laws protecting abortion. A 2022 state law made abortions after 24 weeks illegal and added several requirements like ultrasound and parental consent for minors. In May 2022, Governor Chris Sunan signed a law allowing abortions after 24 weeks in the case of fatal fetal anomalies. In New Jersey, abortion is legal in the state. Assembly Bill 6260, passed in January 2022, protects the right to abortion and removes several restrictions from the law, including the requirements that only physicians provide abortion. In 2000, the state Supreme Court struck down a law requiring parental consent for minors. New Mexico. In 1969, the state passes a law criminalizing abortion, but the state legislature repealed in February 2021. The repeal also removed requirements for parental consent for minors. There is no law protecting abortion in New Mexico, but the overturning of Roe versus Wade does not immediately impact abortion access in the state. New York. The state legalized abortion in 1970, 3 years before the Supreme Court ruling in Roe versus Wade. A 2019 law lifted several restrictions, including a requirement that only physicians could provide abortions. 2019 law, Section 2599-BB, removed abortion from the New York State Clinical Code and allowed abortions after 24 weeks. For the special purposes, in case of life-threatening pregnancy or non-available fetus. New Carolina. Before Dobbs, abortion was legal in North Carolina until fetal viability, considered approximately 22 weeks, but a law banning abortions after 20 weeks is now in effect. The North Carolina General Assembly has also passed several other restrictions, but they all have been vetoed by the Democratic Governor Roy Cooper. In case of North Dakota, the trigger law was passed in 2013, and it goes into effect 30 days after the Attorney General certificates. The Supreme Court has restored to the states the authority to prohibit the abortion. It makes the terminates a pregnancy a Class C felony and the punishable by maximum penalty of 5 years in prison and $10,000 fine, and they accept to save the life of the mother or in case of the rape or incest. In case of Ohio, things got complicated a bit on June 24, because on June 24, a federal judge lifted an injunction against Ohio's so-called fetal heartbeat law, which bans abortion after the detections of fetal cardiac activity about 6 weeks into pregnancy. with an exception if the life of the patient is at stake, but not in case of rape or incest. The healthcare providers found guilty of performing an abortion could face felony charges and up to a year in prison. But the resident who seeks abortion in other states would not be prosecuted. These are the words according to the Republican Senate President Matt Huffman. Oklahoma, the post-Roe, a trigger law was passed that would penalize anyone who performs abortion within the state until mother's life is at risk. The trigger law will go into effect in August 26. That increases the penalties to 10 years in prison or fine of $1 lakh. Like Texas law, the Oklahoma's law also allows citizens to sue anyone who helps a woman obtaining an abortion for at least $10,000 in damages. Oregon has enacted several laws to expand the access to reproductive care. In 1983, the abortion became right under state constitution. Also in 2017, the state began allowing non-physician health professionals to provide the abortion cares and passes a law that requires the private insurers to cover the cost of abortion. In 2018, the voters rejected a ballot measure to restrict the use of the state funds for abortion. Pennsylvania also allows abortion up to 24 weeks after the last menstrual period. In 1982, the state added some valid requirements for abortion. In Rhode Island, abortion are legal and minimally restricted. In 2019, state lawmakers repealed a law criminalizing abortion after 12 weeks and repealed it with a measures that added statutory protection but did not guarantee the right to abortion in the state constitution. South Carolina outlaws abortions after 6 weeks with exception for rape or incest. South Dakota passes a trigger law in 2005 which puts ban on abortion except in case of life-threatening pregnancies. Under Roe vs. Wade, South Dakota allowed abortions up to 22 weeks, but after Roe's overturn, an abortion has become impossible in the state. Tennessee also passed a trigger law in 2019 to put ban on all kind of abortion except life-threatening pregnancies. The law is set to go into effect 30 days after overturning of Roe vs. Wade. Now Texas passed Texas Law 1280 that criminalize almost all abortion except to save the life of the pregnant patients or if they risk substantial impairment of the major bodily functions. The law which makes providing an abortion punishable by up to life in prison and fine up to $1 lakh is set to take effect 30 days after Roe vs. Wade is overturned. But Attorney General Ken Paxton is opposing this law effectively. The Utah, which also passed a trigger law in 2020, and it will take effect after Roe overturn. This law will punish abortion performer with second-degree felony punishable up to 15 years in prison and $10,000 fine. The state Vermont has no major restriction in abortion. In 2019, the Republican Governor Phil Scott signed Act 47, a sweeping reproductive law that established the right to abortions without government interference. In Virginia, the abortion is totally legal up to 25 weeks of gestation. A 2020 law repealed several restrictions, including 24-hour waiting period and the requirement that only physicians provide abortions. In 2021, the state removed the prohibitions on the state exchange insurance covering abortions. Now, the Washington, which is equally liberal like Virginia in case of abortion. In 1971, the Washington state repealed criminal penalties for terminating a pregnancy, and abortions are legal up to the point of fetal viability, somewhere between 23 and 24 weeks. In 2018, the right to abortions was written into the state law that requires insurers that provides maternity care to cover abortions. In March 2022, the states passed a law that shields both patients and the providers from out-of-the-state prosecutions in response to the laws in Texas and the elsewhere allowing citizens to sue the abortion providers. Now the U.S. capital, Washington, D.C., the right to an abortion was codified into law in 2020 with the passage of the D.C. Law 23-90. Which also prohibits the employment discrimination against healthcare professionals who performs or are willing to perform abortions. Now West Virginia bans abortions after 22 weeks except in case of life endangerment or several health risks. It also requires a 24-hour waiting period, counseling and the parental notification for minors. In 2018, the West Virginia voters agreed to amend the state constitution to specifically declare that it does not include any right to abortion. A law signed by Republican Governor Jim Justice in March 2021 prevents women from getting an abortion because they believe their child will be born with a disability. A law from 1848 makes it felony to perform an abortion, the punishable by 3 to 10 years in prison, although it is unclear if the statute is still enforceable or not. Now Wisconsin. In Wisconsin, a law dating to 1849 makes abortion a felony, but it is not clear if the 173-year-old ban will go into effect. As State Attorney General Josh Cole said that he would not enforce the draconian law. The Democratic Governor Tony Evers has called on Republican-led legislature to repeal that law, but it isn't expected to do so. Until now, abortion in Wisconsin has been legal up to 22nd week, though state regulation requires counseling, the parental consent for minors, a 24-hour mandatory waiting period, and mandatory ultrasound. They also prohibits telemedicine for abortion medication. At last, we reached our last state, Wyoming, where the state legislature passed House Bill 92 on March 2022. House Bill 92 is a trigger law that outlaws the abortion except in the case of the life-threatening pregnancies. So, US abortion bill has become different for different states after Roe vs. Wade was overturned. But this overturned decision has hit the American image, being a champion of human rights and democracy. The World Health Organization has already criticized the US Supreme Court decision. Now the questions. The first question is, which of the following word has been written in the preamble of the Indian Constitution, which is the Indian opinion according to the Indian Constitution? The first option is sovereign, second option is socialist, third is democratic, fourth is morality. The second question is, which statement is not correct in case of the sovereign India? The first option is India is not dependent on any country. The second is India is not a colony of any other country. The third one is India can give any part of its country to any other country. The fourth option is India is obliged to obey the UN in its internal affairs. So this is the end of the topic. So if you have any questions regarding this topic or any other inquiry regarding anything, you can mail me to my email address, which is tuhin.power.academy@gmail.com. So I hope you have found my topic informative. So thank you very much. Thank you for your support.